Good afternoon. We're going to go ahead and get started. I'm Lori Munn. I'm the Deputy Director of Insurance here at DIFI. Thank you all for coming in person and for those of you who joined us online. Just want to do a sound check. Everybody online can hear us okay?
Yes.
All right.
Yes.
So, today we're here to talk about the bulletins that were issued. This is a open meeting, and I want to notify everyone this is being recorded and will be made available on the department's website. We will have opportunity for comments. We're going to kick the meeting off, giving a brief overview of the two bulletins, and then pose a couple questions to start the comment period. So with that, I'm going to turn it over to my colleague Ian and have him introduce himself, and we'll introduce the folks there at the table and then get started.
Good afternoon, Ian Olzanov. I'm Chief Financial Deputy Director. And if you're asking why the financial guy here, I'm also pretty involved with the enforcement units. I came from the enforcement unit. I was the legal officer, and then I'm assistant director over the legal side. So pretty much still involved in the legal aspect of the department's dealings, but also in these processes, such as the two matters in front of us. I guess maybe I can start with a question. I think,
You have to really
Sorry.
introduce yourself. Sorry.
For those of you that haven't met me, Gio Espinoza, I'm the Assistant Director over the Product Forms and Compliance.
so I guess everybody has seen the bulletin, right? I can do a quick overview, but I don't want to read it. I think everybody has seen it, and I think people have commented on it. So unless anybody wants to for me to actually read the statutes and what our position is, let me know. But the general overview is that on April 25th, 2025, we issued Substantive Policy Statement 2025-02. This one has to do with service contracts. And in it, we explain how we noticed a trend of including what seems to be a service contract coverage, which are these individualized coverages for consumer products, into a general insurance policy. And I think we all have insurance. I think we can agree they do look different. We have warranties and we have insurance policies. They are written differently. They are triggered differently. They are covered differently. And that's why I think it stood out to us. So once we came to the legal team, we sort of noticed that the statutes define a service contract coverage separate and distinct. And actually the statute says for a separate consideration, you can offer this and under your license as a service contract provider. And I think that's our objection. We've laid out the statutes here. We've laid out the definitions. And our position is that if this is to be done, it needs to be done in accordance with the law, which is getting a permit and for a separate consideration, sort of making it known to the consumer that, hey, you are going into a different type of coverage here than, let's say, liability for vehicle insurance. That's our general position. You've seen that we understand that this has been used for some time. Obviously, that's why we're being very cognizant of the industry, and we have given the industry about almost 2 years of time to figure out how to do this. Different solutions, maybe change in the law, but that's up to you guys. So I guess the first question, if you don't mind, to the industry and to you guys is, now that you've seen the bulletin, you've seen the January 1st, 2027 sort of moratorium on enforcements. What do you plan? What does the industry plan to do in this period between now and January 1st, 2027?
And we'll strictly address service contracts first, and then we'll move to the second bulletin just to kind of define what we're talking about, and that we're going to keep the two issues separate for the purpose of this meeting. So if there's any comments to that.
Yeah, I don't know. So, I think the hope for the industry, at least a lot of my clients, was that we have a good dialogue with the department to see what are the specific kind of take the statute definitions, and we can agree, disagree, that sort of things are covered. But are there like consumer pain points that you want to have addressed, and why you want it treated as a warranty versus let's say we didn't have a statute, you didn't pick how you wanted to regulate it. And then use that as a dialogue. And then as the result of the statute change or some refinements, but, you know, we want to figure out what would reduce your concern in those areas. And then either change the law to make it reflective or, you know, have a dialogue about that. You know, I do see some of these policies, I call them like kissing cousins. They're similar, the warranties and insurance products.
So first, can we back up? I have one step. This is a public meeting being recorded and there are quite a few folks online. So when you do address or comment, could you introduce yourself and what firm you're representing or company?
Oh, yeah, that'd be Mark Osborne. Here on behalf of Kuchak Rock, we represent a number of different insurance companies in the states, mainstream carriers and such.
Thanks, Mark. And just going forward, when we move on, let's follow this. I appreciate it. So, do you mind?
Sure.
Just, so with that, addressing consumers, you know, that is our number one priority. And I believe that when you intermingle these, and that's the purpose of how the statute was written, is that it's not clear what services, it's not an insurance product, and it's another service being inserted into an insurance policy. So for the consumer, I think they need to be aware that they're getting something outside of their normal coverage. And a lot of times it's hidden or it's endorsed or it's, you know, there's not a uniform way it's being provided in policies. So with that, how does the consumer really know? And I think that's what has kind of brought some of this to the forefront.
And I think that's fair. And I think that's a direction I think we would appreciate is kind of have some discussion sessions in the future about the different products in the market and maybe have some of the companies present and talk through why we think it's warranty, why we think it's insurance, and what are some of the differences. And then also have specific dialogue about, okay, let's create some uniformity so we all,
And I think
certainly it's a uniform experience. I think the industry would be very open-minded.
And what's happened is I think it's evolved over time. You know, it used to be roadside assistance. As you know, I have an industry background and most policies, it was just the roadside assistance type of coverage. Which, but as time has gone on and things have gotten more complex, and more services are available, those are being intertwined. And, you know, I think you all agree that insurers, consumers don't read their policies anyway. So our job is to make it easy to make sure what they're getting and they understand what they're getting. And if they're getting something that's outside of the normal insurance policy, then they should have that notification.
And I would also recommend that we do on the home side and have some discussions and then the auto side. I mean, it's similar issues, but they're a little different. They're a little different.
And I think that's a good point of the companies presenting, sort of like founding the boundaries of this, because they are boundaries, we agree. Roadside assistance, that we're not objecting to that. So I think the best thing to do is to have the companies that said present or so give us a document of here's our argument why this should be allowed under the statutory scheme, and we can review it, we can talk about it. But I think to open up the conversation, this is great, but some sort of filing, some sort of written document so we can go to the legal team, we can actually have them to review it. I think maybe for the next meeting, if we can ask the industry to give us their best argument or the best position about where's the boundary? Because again, we do acknowledge there is a boundary of what is a warranty, what is a policy, and where is that line being crossed. And
Or
also,
service, because they're not all warranties. Some of them are services that fall outside of your typical warranty, but still would be provided by another company other than an insurance policy. So just wanted to clarify that. Yes.
Don Isaacson, representing State Farm. Just some clarification. I've never had to think about this stuff before, so it's new to me. Is it an issue of whether, A, there's additional compensation for the service, or whether it's offered as a rider to the policy, or whether it's embedded in the policy coverage itself? So if the policy covers without an additional compensation and without an additional contract document, a particular service, roadside assistance, emergency roadside work, whatever, does that make a difference on whether you need a separate permit for that work?
I think, and again, going back to the statute, that's what we did, which is if the coverage triggers the statute of what is a service contract, then yes, once you trigger a service contract statute and definition, then you need the permit and you need to follow those specific set of regulation, which is separate consideration, you get the permits. So I guess my answer would be, it goes back to what is being covered. So it's, what is the coverage? I don't think it's so much of the compensation comes after. So it's, do you need a license to do what you do? I don't want to go into hypotheticals, but let's say key fobs. If you have coverage for key fob, that is directly found in the definition of service contracts. That triggers it, right? For you to get specific coverage for a key fob, that is a warranty card. That is, and again, when I say warranty, it is service contract. It's the same under Arizona law. That is a service contract. So for you to offer this coverage embedded into an insurance policy, we believe you need the right permit, which is service company, and it needs to be for a separate stated consideration, which again, this is what the law says.
And that being, there's separate disclosures and consumer notifications that are involved with that as well. If you look at the statute.
Follow-up question. I think one of the
Mark,
things
will
that
you just introduce yourself?
Mark
Sorry.
Osborne, here on behalf of USFI. I think one of the things the industry, put it on the insurance side, because I've done work on both sides, that was kind of curious to us. We've always kind of thought the insurance side tend to have more consumer protections. They're different. And the question is, from a policy perspective, where do you want to ideally put some of these things? Right now, they're in warranty, but does it make sense for the key fob? Could you also have a parallel product in insurance? And what are the pros and cons of doing that? And how do you balance that versus consumer confusion and what have you? I think that would be a worthy conversation.
I think that's some of the conversation we're trying to get from you all to provide us with, what are those scenarios and what does trigger certain things in an insurance versus a service contract.
And also just want to go back to, I think for us to get to that point of the conversation, we still have to deal with the statutes, the interpretation, because again, key fob, if we stay on this, how do we read it differently where key fob is expressly stated in the definition of service contract coverage? How do we overlook that and say, well, because of public policy, we should allow it as an insurance? Like again, car insurance liability. One of your coverages is liability and then key fobs. How we just cannot overlook the statute. So I feel like that's why going back to the beginning, which is what coverage, what policy, what conduct triggers a certain definition within the regulatory framework. If it does, then we have to follow that lane, which in this case, key fob, you got to follow the lane of service contracts. So before we get to the policy and all these conversations, I think we need to first deal with the statute. What triggers it? What is it triggered? And if it is triggered, you have to follow it, right? We cannot go beyond that. So we cannot go beyond the statutory interpretation piece to get to the policy arguments.
Ward Tisdale, National Association of Mutual Insurance Companies. I probably should have researched this first, but how old is this service contract statute? I'm just.
Good question. We can get back to you, but it's pretty. It was updated some years ago, but I don't know the exact.
I'm saying 5 or 6 years.
5, 6 years, but we'll get back to you on the exact date, but it's been there for a while.
And so it's only recently that you've been discovering that there are this commingling of insurance policies.
It's a little bit of that, but also, yes, I mean, the department has been communicating this for some time. That's why I think there has been some objections there have been a lot of conversations with a lot of industry. I don't know, not to point anybody out, but it's more of a trend that we've noticed sort of amping up. And I think that's what the need for sort of this universal communication.
And you mentioned roadside assistance before, you said that was okay, right? Or that was sort of teetering on not okay. I'm like,
Yeah, I mean, again, like, that's why it's so difficult to get into exams, but I did mention that I think we have stated that the roadside assistance is ultimately it is a vehicle liability coverage. Because it's sort of resulting from an accident, it's sort of like what insurance is, where in some cases, and again, these are like outliers maybe, but there have been very much a service contract type of a policy, which you would imagine. If you have a vehicle, your engine malfunctions, you need to go to a mechanic to get it approved to get it fixed. If people can all agree, that's not insurance coverage, right? That's not how insurance coverage works. So like, again, there is a huge spectrum of this. There is the EFOD, there is this, there is all of them combined. And I think that's why we need to have this conversation of where is the line? And I think if the industry can commit to some sort of position on this, we can review it, and at the next conversation, we can sort of flesh out the boundaries.
So the statute was updated in 2021. So it's not 4 years ago, there was an update to the statute.
Okay.
But the other thing is, like I mentioned, is how it's being presented. Sometimes it's being actually put into the policy itself. Sometimes it's endorsed. There's no consistencies, and to be honest, it's very hard to see it sometimes if you even have that coverage, but it's being provided.
Dave Brown with Progressive. I had a maybe procedural reactions, like how this felt to the industry. In our case, we approached initially with a filing and had a mechanical breakdown type product service included that was objected by the department and is not allowed. And so we, understood that, but if we pointed out, well, level playing field, there are other similar products in the marketplace, it seemed to us, and I think that's where we first learned that this was on the department's roadmap of things to work on. We also had another product line, this kind of as awareness of this issue was elevated through, I think, an advisory meeting where we talked a bit about what was on the department's agenda or roadmap, as I should say. And the service contract was something that was brought up as something that you were going to be looking into, our other product line, which is, a property, said, oh, well, what does this mean for us? Because they have some appliance warranty, which is, we talked about being something that you think is, again, in the service contract area. But on the flip side, there were the roadside, and I think I heard at one point, I don't know if it's true or not still, or your position or not still, like sewer backup and things like that. So I think from an industry perspective, we need to know, like, with clarity, which ones are in or out of the scope for, this issue, because it makes a difference in how we set our products up. I also would say that, there's a time frame that's been announced, which, again, I appreciate that there is a firm date at which something will happen in January 1st, 2027. The question becomes, in advance of that, we need certainty as to, okay, this is the final offer, you know what I mean? So that we can start to build towards compliance. So I guess my main points there would be clarity on what's in and out of scope and a time frame by which the final decision will be made, so carriers can know with certainty and, the level playing field will be maintained.
And I guess this is the point, right, of this conversation. So again, I think it's a good start to industry. Why don't you tell us what you think these boundaries are? Where does it cross and where does it not? And I think we have to go back to, honestly, I've had many conversations on this. I have to be honest, no one has presented an alternative reading of the statute. So give us an alternative reading of the statute. I think there's some disagreement on our position, which is just laying out the law. tell us, what do you think we're missing? Where is there, are there any gaps? Have you seen any gaps? And again, so maybe next time, I think there's some commitment to filing of some sorts to us to review prior to the next meeting. We can work on dates. But a position of the statute, how you read it, what your position is on statutory interpretation, and then based on your reading, here is what we think should fall under a insurance policy coverage. Here is where maybe some of these key fob goes out of it, outside of the lines. So again, collaboration, we are an enforcement agency. We can only enforce the law. And we can work with everybody to sort of come up with some certainty. I think that's important, but I think you have to provide those arguments. And we can have a conversation on whether we, based on the statute, we agree. But again, we can help you in fostering the conversation and then maybe having some certainty, maybe through a follow-up document such as this. But we need your input.
That's been our ask, we've waited for the input and we've yet to really have any input definitive, other than talking around it a lot.
Yeah, I think Nate Brown is progressive. I think there is some confusion and to make that more clear from our perspective, it's like, well, why is roadside okay? But if we understood the thesis behind that, we might understand how to apply that thesis to other lines. And of course, I want to keep, roadside in scope with the product. That's kind of the status quo. But I think that's where we're struggling. Is a little bit to understand why is one set of existing products viewed one way and not the other.
And I think, Nate, it goes back to the statute, how the statute's being read. And that's, if you see something in the statute that's different, that's what we're asking you to provide us with.
Understood.
And can I just for a minute, if you're online, and you want to comment, if you could just raise your hand and we will call on you. I failed to mention that at the beginning, and I know we had quite a few folks join late. So if you are online and want to comment, just raise your hand and we'll call. And with that, Laura, you can go. Introduce yourself, please, online as well.
Of course, no problem. Good afternoon, Laura Curtis with the American Property Casualty Insurance Association. Thank you for the opportunity, at least bringing everyone together. Just want to reiterate what some of our member companies have already said. I think that it's really confusion from the insurers that I'm hearing from as to what's in, what's out. I will absolutely, go back to our folks, get the read of the statute, kind of what our arguments are with regard to what we think should fall in and what should fall out. But I just want to reiterate that's really where the confusion has been, is that it feels arbitrary. And so since there's not at least not to my understanding, been a clean line as to what should and shouldn't be considered, that's where the issue lies. But we'll go back and look at the statute and see, put together our best presentation onto what we think, should and should not be included. And then at least have that presented for next meeting.
Thank you, Laura. Any other online? Okay. Any other comments?
Don Isaacson, State Farm. So at least the way the department is looking at it at this point is look at the service, and if it's either specifically one of the ones listed in statute or of that nature, because I don't think it's an exclusive or inclusive statute. I think such as towing, such as rental, etc. That is what triggers it, and that triggers the need for a permit if that particular item is added, whether it's a rider or whether it's embedded in the policy. And it's just taking that the next step. If a permit is filed and the department approves the permit, do you contemplate that it will lead to a restructuring of the policy? For example, if it's embedded in the policy now, does the department see this going forward as needed to be provided as a rider or a supplement to the policy as opposed to in the policy itself?
And if I could just jump in briefly here, I'm with the product forms and filing division. So I'm going to maybe not answer your question fully, but I can say that it's all about consumer confusion, right? And I've seen what's come in, blended in a policy to the consumer. They would have no idea. I can see it, and I see almost if it were highlighted the service contract embedded with it. What I don't know is what's that doing to pricing for the consumer? what does the use of those services under that service contract embedded in the policy, for example, going to do to the rating factors for the original homeowner's policy? So that's a discussion I think with you all is what's going to make that easier. I think, Mark, you alluded to that earlier. What is it that's going to fix that concern for the consumer? I think clarity, right? Because if it is embedded and no one knows it's there, but it's being used, but is that service contract being used going to impact cancellation, non-renewal, things that should happen under a regular insurance policy? So these are just questions, and I'm not picking one thing in particular, but I'm just pointing that out. I think to your question, if endorsement or embedded, I think it still, depends on how clear that is and what is there going to be, is it combining of factors? I mean, are those going to be clear? How is this being priced? And I think that when we go back to consideration, that's why that piece is important, because you're pricing it on that risk for use of that services, but you're embedding it into an insurance contract that has its whole other, scheme, its rating scheme. So I hope that answers your question, but I don't know that we would want to see it embedded or not. I think it's more to answer the consumer confusion question. I think that that's a discussion that could be proposed.
Thank you. I have a follow-up question, and that is, we're basically talking about personal passenger auto and homeowners. We're not talking about commercial policies, business policies, where there may be similar or supplemental coverages as well. We're talking about consumer products on consumer policies, just for clarification.
Yes.
Thank you.
Any other comments in the room, questions?
This is Mark Oswald. Just to be clear, what's kind of your I know you want to have kind of a dialogue. Do you imagine like a comment letter or presentation or
So,
since I'm the one coordinating a lot of this, so.
we had a chance for the comments prior to the bulletin, which we got a few, but not a lot. So I would say after this, a follow-up meeting probably, Mark, would be best, I think, and for you all to come back with some type of presentation, or like Dean said, some type of giving us some scenarios, or, outlining how you see this and how your interpretation is of the statute. And, like Dean said, it starts with maybe the statute needs changing, and that's, we allow time to get through another legislative session if need be for y'all, because that is another avenue to take.
Yeah, I was gonna say, it has to go back to the statute, because we can get your comments, but here's the statute, here's what we presented. So if you think that, let's say, key fob should be insurance coverage, it has to be a statutory change. So I guess we can have this conversation of maybe finding what could be allowed, what isn't, if the statute is vague. Makes sense, but on certain things, if there's a specific individualized coverage for consumer products, then I don't know what we can do about that outside of the industry is seeking some alternative way of changing it, which is statutory change. We can have to.
This is Mark Osborne again. I think what we want to do is give a sense of, policy, if we have to change the statute, does it make logical sense for this to be in this bucket or that bucket, and have that discussion so that we're not just being arbitrary? Because I think there's some arguments, key fob very nicely as an insurance product, there's arguments, and also probably some very good arguments why policy-wise it would be service, or maybe you could have it in both, and what's the issue of concern about doing? I think that's where we want to see the discussion and kind of go to the major products that are in there in this concept. This makes sense. Does the statute back that up? If you want to make it clear, then change the statute, and then we will find what statutory changes that we need.
Anyone else on this topic before we move to the next bulletin? All right.
Just to summarize, so the plan, again, we can work on the next meeting, month, 2 months from now. do we have a commitment that there will be some sort of filing to us, not official, some sort of document filed to us with, again, laying out these arguments, and I guess what the ask is based on the current statute and the current interpretation, and then as a follow-up, we can have a conversation based on these actual arguments in front of us, because we've heard arguments, but I think for the first time, we're getting to the issue, which is that, so again, a summary is that a plan? We're gonna wait for some sort of documents, filings. Do you want us to facilitate it? Do you want us to put something on the website, or is this audience here enough to talk for everyone involved?
So another open meeting, that's what Dean's asking. Do we need to schedule another open meeting, or do you guys want to just take this and have another meeting to discuss next steps?
I think an open meeting probably makes sense, just to keep, my side's mainly, insurance side, actually, sort of. But maybe what we can do is we can kind of put it on an agenda. So you get the information you need, and what you might want. But I don't want to use a huge detail. I think it's probably better if we almost do a PowerPoint or walk through it and say, these are the companies, here are the arguments, pro con, and we discuss them. I think that would be good.
Okay.
Within a month?
Yeah, that seems nice.
Then, moving on, advisory rate service organizations, again, same thing. We have seen a trend of some companies sort of getting into this business. Let's say this is a specific type of business where organizations, not the insurers, engage in some sort of assisting an insurer with data, statistics, compilations, and we believe that these trigger the aforementioned statutes here. Again, in the Bulletin 2025-02. Again, I'm sure everybody has seen it, but the statutes do, all we presented was the definitions again of advisory and rate service organizations. They are different. And I think maybe just starting off from the beginning, the arguments we've heard is that the industry believes that there's some sort of a judgment call in this, where the statute just says assisting. I don't think the statute says that you have to advise the companies, you just assist them. To us, that's a pretty broad term, and assisting means collecting data, putting it in reports, providing it to the insurers. Because if it wasn't for the advisory, I would have done it myself, right, the insurer. But I outsource it to an organization that under the statutes needs to be registered in this case. It's not even a licensure. And again, we've seen this happening. Just for backgrounds, there's quite a few companies that have these. Somewhere here I have them. So we have, sorry. I mean, I believe it's 27.
Are you looking for the list of registered?
Yes.
Yes.
It's like 30 something. Had a couple of issues.
No, that's what happened. 27 registered RSOs, rate service organizations, and 17 advisory organizations. So again, it's an industry. People following, companies are following the regulation and they're getting registered. And I think there has been more recently coming on board and applying for this registration. Again, opening up to you guys, this is same issue, same approach. We understand that this might take some time. We understand there might be a different interpretation. So what is the different interpretation of these statutes? And also, what do you plan on doing until January 1st, 2027? Well, what steps is the industry doing? Can we help? How do we work on this?
Con Isaacson State Farm, I think it would be helpful if the department has a clear vision of services that are covered and services that aren't in the traditional insurance world. that would be helpful for a start for us, because it's not an exhaustive list, it's more characteristics in the statute. So of all the services out there that insurance companies use, it'd be helpful to know as a starting point what you look at as covered or should be covered as opposed to uncovered.
I mean, again, I think starting with the obvious, I think what I said is if you are outsourcing the collection of data to an agency, to a different institution that is not yours, the insurer, that's an advisory organization.
It's more with the rate making piece of it and the models that are being done and the pieces that are going into developing a rate. As they've become more complex, they're using more data, they're not just a piece that the company's looking at anymore. They're actually being used to develop the rates.
I mean, one example would be, I guess, public records. Do you see that as a public records review and looking at MVRs or others? Is that and it's a data source external to the company itself? Is something like that when you're tapping into public records? Is that?
That's not being put into the rate itself. So in the past, it was more like the consumer stuff like DMVs and things that were used for underwriting, but not in the development or assisting in the rate making process. Whereas now with all the complex modelings and the things that are happening with some of these companies that they're providing, those pieces are put into the development of base rates. So they're using more complex, because when we're getting the filings, the justification or the stuff that's being, the supplemental rating information has that information in it as being used to develop the rates.
That's helpful. I think if you have, again, of all the swirling subject matter and types of information that companies use to develop rates, you know that because you see it. If your instinct is these should all be independently registered with the department, licensed by the department, used by the department, used in front of the department, it would be helpful if you have a list of those by category, what that is.
Because it's no more just the credit scoring, and you all in, the state, it used to just be credit scoring, and it's no longer just credit scoring that's being used. It's much more complex. And, we'd love to hear some of the companies in the room as well.
Nate Brown with Progressive here, and your comment there just made me think of an example. In regards to credit scores, some companies develop their own, and others use off the shelf or purchase data. And so to me, it begs the question, could the same third party be an advisory organization for some carriers, but not for another, but still provide them with data? So if the carrier's doing their own work independently, is that, can you parse that?
Well, if you're doing your own modeling and you're sending a filing in and you've supported it all at the company level, then that filing would not have any advisory organization or have any implications, because you've not used any support from a third party to support your rates. It's all coming internal from the example you just gave.
Yeah.
Lauren, is it okay if I make a small example from a practical perspective from the finance division? So, for example, if we have models that come in from XYZ carriers and we're reviewing them, they're going to be reviewed individually because we don't know if it's an entity that has an approved model because it's a rate service organization and they submitted a filing and it includes vetted already product. So we just need to see how they use that, how they tweak that. We have a conversation with the carriers, with the actuaries, with the stakeholders, and they can answer. On the flip side, if we have a carrier who's using a third-party model that we've not vetted yet, that we don't know what's necessarily in it, then we're kind of vetting that product through proxy, through the carrier that's submitting it, except that when we have the call to ask what's your secret sauce, what's in that, what's contained, they can't answer the question. And so that's kind of what prompted this is it's very difficult, especially when we're a small department and get these filings in and trying to do, our due diligence on these models. We have a great team. But at the same time, it's very hard when you're trying to get answers from actuaries, but then have to have a different entity on the call. That's not registered with us. We haven't reviewed their models previously. And so in that scenario, you have 10 filings with the same model, for example, uses the base. Every single one of those models is going to go from beginning to end review. It's not going to be just how is this carrier using these variables, using these factors. It's inefficient for the carrier. And it's inefficient for the department as well. So I just wanted to share that small example.
I think to that point, Mark Osborne, you know, they have numerous insurers and also LexisNexis. And one of the things that when we were having a legislative discussion around this, can the race pass? I think there is a lot of interest from some of the support companies that if we can find a streamlined mechanism where we can file different models so you can pre-approve them and they become it's more efficient for you and more efficient for the carriers. And I know that may require a statute change, and I know there was some hesitancy to go that approach without having a more robust stakeholder process. And I think we could have some real win-wins where you get more exposure to the models earlier on, they get approved easier, it's more streamlined for you guys. I know on behalf of LexisNexis, they're always happy to support the carriers in their approach, but we probably have a much more efficient way to do that. And I think a lot of the companies would be willing to do that.
Yeah, and again, it would be a legislative change because right now that's not, they do have to be registered and and what you said is true because I actually came from an advisory organization and when you can get your stuff pre-approved that could auto be adopted by companies, it's much easier for everybody.
And there's 17 states that allow us to file models. I may be wrong with the number. That may be helpful to look at some of those, at least regulatory approaches and then figure out how we can structure that. I think the other point is if you say the word assist, if you interpret it so broadly, I think you could read it to say, if you collect any baseline data, you need to be licensed. And that I think can be a very high burden for the carrier because a lot of these companies just provide raw data and that means assist. A lot of them are probably not going to want to be licensed in all the different states. So I think we need some clarity on if it's assist, what is that? I think you have models and other things, and you have the clear things that are making rates versus I'm pulling a very basic data source, NOAA weather or something like that in a model does NOAA have to be
Well, the key is it affecting the rates? So you got to remember this is around the rates themselves. In the rate making process, I think is how the statute reads. So if it's something that NOAA's doing, but it's not really affecting that bottom line rate being developed, then that's kind of out of scope, in my opinion, in that example.
I guess weather would be somehow impacted. I think it's not as clear cut.
Well, if that was the case, then it'd probably be a model, which would then make it into the rate. So yeah, again, it's a fine line and it's, we're asking again that we're just interpreting the law how it reads now.
So Nate Brown here with Progressive, just trying to make sure I understand what you're saying. Carrier has their own loss experience and a new variable comes in, whether you're left-handed, right-handed, or ambidextrous. Your loss costs don't change. The amount of rate in full you're charging doesn't change, but how you segment it to different insureds could change. So are they assisting you by providing that third-party data with no loss experience and you're just assigning it to your own, categorizing your own risks? That's where I want to understand your perspective.
In that scenario, I think we would say it's assisting
Yeah, I guess
under the current statute.
Yeah, I mean, I guess basic statutory interpretation, right, assist, it is a broad word, but was chosen by the legislators who know what they're doing. So I guess, well, how is it not assisting? Honestly, well, no, I mean, that is, no, that's in case. How is it not assisting? Again, it's, if you bring it back to the basics, you're not doing it yourself, you're outsourcing it for somebody else to do something that ultimately goes into your rate making. Help us understand, how is that not assisting?
Well, if Nate Brown, the progressive, if they're saying, here's a list of people and whether they're right, left-handed or ambidextrous, and we're saying, okay, well, I know those folks in my book, so I'm gonna then take that information and do something with it to figure out how I want to
But
rate.
you're creating the secret sauce. You're not.
We are creating the
Exactly,
secret
but
sauce.
that- You see that,
I see that as different than them creating a model and saying this is the losses that they.
I mean, it could be a model or it could be three factors, have different weights on them that you and I don't know. That's the secret sauce. And then you're getting that from them and you're plugging it in. That's and I'm not arguing that getting the left-handed, right-handed folks
Yeah.
is assisting. I mean, it's arguable, right? And that's kind of why we wanted to get your positions on that too. Because as far as I'm concerned, for every statute, for every rule, I mean, you can have two sides and we want to see how that works. But we do think that assisting is broad, but I don't think that our position has ever been that you get an MDR report and that's assisting, aside from a government entity like ADOT being statutory excluded from any type of, requirement to sign up as an RSO or an AO. That's not what we've stated in our positions, in our conversations with industry and calls. Because I've been on numerous dozens of calls. That's never been our position. So I think there's something more to that.
Thank you. More of the same. John Isaacson, State Farm, it just publicly collected and available data, US DOT and others on crash worthiness, vehicle weight, vehicle size, vehicle features, not supplied by a service, but it's everything that a company takes in. It probably coming from a government agency, they have no interest in registering with the department as a source of information. So I think where all this commentary leads is it'd be very helpful with the department, for us, if the department has a vision of those types and those sources of information that you see that need to be independently registered and those that don't. So that, I think that'll immediately get us to issues of compliance. And if there's disagreement on one or more items, we can raise those.
I think we had someone online who wanted to speak.
Courtney Much from the Doctors Company. I had a similar concern that some of the outside data sources that we reference also are for segmentation of rates, not to affect the overall rate level, but are coming from sources that would have no interest or motive to register with a Department of Insurance, because the data that's available is not primarily for insurance reason. It's primarily collected for some outside reason. And I think that would apply to the NOAA example, to the crash data example, to what I have in mind has to do with Medicare billing data. It's not directly collected for the purpose that we're using it for. So with this broad interpretation of the statute, it could eliminate the usage of many of these data sources.
Thank you. Any other comments in the room? Yeah.
Do you want to set up a similar industry comes with comments about your presentation and why? And then maybe talk about some of the other data sources, down that continuum, like we did for the service contract?
Yeah, I think that's a great idea. And what we were just kind of trying to talk about was, we could probably do them on the same day, just like, one before and one after, or an
Thank
hour
you.
apart, just because so many of you travel in for this. If you plan to come in person again, I hate to have you come two separate times, if that works for everybody, to try and do another, like a 2-hour, first hour, one, second hour. That's an agreement with everybody. But I think, first and foremost, I think we all agree that the statutes themselves are not written really in a way that needs to be looked at to first and foremost to see how that can be addressed. Is there any?
I have another question, and I'm sorry to dominate Nate Brown with Progressive here, but I've been thinking about this for a while, and I want to make sure we make progress. We only have so many months to get this sorted out. During the session, there were suggested new definitions, coming up with a third definition for something other than, modeler or whatever. Just at a high level, the concept of creating a new definition, I hear you saying, well, it's got to be in statute. So if the statutes did that, are there any policy reasons why you wouldn't want that to happen? We want to work in concert with you and not, kind of jam something in that's not going to align with your view of the world, and we end up right back where we started. So that's one question. And then I guess the other piece of that is because the advisory organization definition already exists in your mind. If you come up with a third definition, modeler or whatever, you also may need to adjust the advisory organization definition to pull out whatever piece you just put in the other bucket. But that's how I'm thinking about it. I just wondered if you've had any thoughts around that.
Yeah, I haven't really thought about that. I know, and did you say there was some talk to do at this session, or it was on the, do you know?
I was under the impression that there was,
Yeah.
But I'm not certain how far it got along.
Yeah, this is Mark Osborne again. Yeah, we proposed kind of a third path, and I think the concerns are different for the department is we need more robust stakeholder discussion before we make such a big policy change. We need more time thought about it. So I guess where the goals are coming up. But I think there's some vulnerability at some point in the process about different options. Clarify. The assist is so broad that it encompasses even the use for public data sources. I don't think anyone, probably your department doesn't want sure not to use as robust the data as we can. That typically benefits to rates, rates.
Well, and we have the list here of all these people who have registered, and it'd be interesting to go through this list to see what services and what they're actually doing. I'm throwing that more out to you all, not me, but that might be a starting point for you all. Is here is all of these people did take the time to go through the process, and they are companies that we see in filings as being part of the filings that are being submitted, or their whatever services they're providing. And, some of these are your typical Verisk and your AISs and NISs as well, that they follow and they get registered, and then they do their filings and all their due diligence. And so that might be a good starting point to see where do these folks fall that have registered, and what services are they providing? Is it the models? Is it the form development or the rate development themselves? We know with your ISOs and your other advisory organizations, they're doing the loss costs, which is a major piece of the rate process. So just looking at this list, that might be a good starting point for you all. Yes.
Sure, like you, the Consumer Data Industry Association, just wanted to echo Mark's point about the consent public. So that could be that.
Thank you. Anyone else? One online that you may not know this? Okay.
Nate Brown again with Progressive. I would make the same comment. Wherever we get to on this, we need clarity with enough time to adjust our product. So even though it's a January 1st date, I think it would benefit us all to have a date at which a decision has been made so that there's time to implement. Because I'm going to assume come January 1st, wherever we've landed, whether it be statutory change or regulatory scheme adjustment, there's going to be time to program it and put it into play. So I just put that out there that even though we have a firm deadline for, well, there's a deadline in the notice, let me say it that way.
And you know, it's 27, not 26. You said a few
27.
months. I was like, wait, it is. It is.
27.
Yeah.
It's, well, that's like 18, I don't know, whatever. The point I'm making is it takes several months to program some of this stuff. So wherever we land, we need to know, okay, that's the final position so that we can get compliant. That's carriers want to be compliant. They want to sell policies. They want to serve customers. And, there is some lead time to that.
All right, so we'll look to post something about another meeting. It will go out on the department website as an open meeting. So look at the website. We'll also try, and I know this last time I can post something out in the CERC product as well as far as the meeting notice. So let me know. Again, if you have any additional comments, feel free to reach out to any of us up here. We appreciate you all coming.
Thank you.
Thanks, everybody online.